this one?
No, let's just go to the next.
Okay. Ready for the next one? Ready to go to the next one?
Go ahead, please.
Okay, so I like this one, but I think it needs some correction, so that's why I want you to do it one at a time. I'm fine with the BBA. You want to have any comments on that one? I don't have any comments on the fixing that sentence in the GDBDA-R1. That one's fine. But I do have quite a few things to say about the proposed policy. And so once again,
But it's not listed in this one.
yes, it is. That's, once again, I recommend we take them apart.
Oh, okay.
And I kind of recommend that we table this one until next month so we can talk about it when we're fresh and not at the end of a 2-week marathon of decisions.
We've had this proposal in our email, and we've had it for the last week as a board agenda.
Okay,
I'm ready to vote on it.
Me too.
okay.
I find it violates federal due process for teachers, and as a board member, it's our responsibility to ensure the school's operation. It's not our responsibility to run them. I think that's infringing upon that as well, which is why I don't feel like it even merits a discussion.
Okay, I'd like to add something to it. We read the attorney's advice on it, which, you know, however many different attorneys you want to ask, you probably get that many different opinions. And we read some advice from other places that I think lots of them were not just common sense kind of unreasonable, but legally speaking, if you go and look up the law, they're misinformed. They are inaccurate. And so if you want, I'll tell you some of the things. Okay. Since this policy was clearly amending the way either a termination hearing is being held or a suspension is being held, there's no reason to not know what policy it was amending. It was amending policy GCPE or GCPD. Both of those have to do with either suspension hearings or termination hearings. And both of those are based pretty much on state statute, what the state statute says. We could say that was modifying either section C or D. There was a problem with the fact that it didn't mention which policy it was. So I'm telling you it was GCP or GCPD, you can tell just by looking at the policies that are in existence and seeing what it amends. So here's a couple of different dissecting kinds of questions. You know, I'm an analytical person from what things the attorney suggested. So I just want to make sure I'm understanding what is being said. That if a teacher appeals a decision of an administrator, to the board, that somehow violates their due process, right? That's exactly what due process is having a chance to appeal and to have a hearing, a teacher or an employee, anybody. And in policy GCPD and policy AC and the state statutes that those are based on, each one of those actually spells out that they are supposed to have a hearing. Policy AC goes through the grievance policy, the grievance procedure. And if they work their way through the different channels, eventually they can appeal that decision to the board, and the board is supposed to hear it. And you might remember when Mr. Peterson was here, the executive director of board training, and he talked about even if there's an appeal, an employee appeals a decision of the administration to the board, especially the superintendent, if that gets appealed to the board owes that person, that employee, a right to have that hearing. And that's what this policy is addressing, that there's a hearing, that there is information sought from both sides. State statute spells out that it has to be public. The attorney suggested that it shouldn't be public, but state statute spells out that it has to be in some cases, and our policies say they have to be public also. So just some different things in there that have been suggested or recommended that I don't think quite make sense. There's another one. If an employee asks to be heard by the board, then it's a violation of the Missouri tenure law, I don't think there's any way to justify that. If you read what the Missouri tenure law, it just says the different specifications for reasons why a tenure teacher can be terminated. There's no justification for that. There's another one, they said it's a violation of board policy. And as I've already talked about, it's actually if they had a hearing, if they did get to appeal a decision to the board, then that would actually be going along with and complying with board
But
policy.
they can't have a hearing at the end, I mean, there's policy for hearing. You can't know it up until this. The 14th Amendment says that they get to appeal, and we have to be a neutral party, so we can't get in the weeds.
If after they're fired, that's one case. But another case is if they're suspended. State statute says if they're suspended for more than 30 days, they're supposed to have a hearing before the board. If they're suspended for more than 30 days, the superintendent brings a report to the board. There are many different examples of times when the board hears from one side what's happening, and they're supposed to also hear from the other side. That's the definition of due process. The 14th Amendment guarantees that due process.
To a fair and neutral hearing once the decision is made.
Before the decision is made, while they're suspended, before any other decision is made. That's what the state statute says.
I'm gonna call the question.
Okay, we have
Yeah, several other things to say.
motion to call the question.
Yeah.
Call the question.
I'll second that.
In order for the question to be called, which means debate will end and we'll vote, we need a 2/3 majority vote to take the vote. So all in favor of calling the question, raise your hand. Any opposed? Okay, thank you. And so we will now vote on the motion, which is to approve the policies as presented. All in favor? As stated in the agenda.
The staff recommend.
Yeah, the staff recommendations, thank you. And all in favor? And any opposed? Thank you. Next, we have approving the CSEP